The chair will call case number 008287, 269-273 Putnam Avenue. Anyway, I didn't look at it. Before you, please sit down. And identify yourself in the record. I want to make a statement before you start the presentation.
Good evening, Mr. Chairman, members of the board. For the record, my name is James Rafferty. I'm an attorney with offices at 675 Massachusetts Avenue. I'm here this evening representing the applicant, seated to my right, Louis Mastrangelo, M-A-S-T-R-A-N-G-E-L-O. To Mr. Mastrangelo's right is attorney Odin Anderson, A-N-D-E-R-S-O-N. He is co-counsel and represents Mr. Mastrangelo as well.
Okay. What I want to announce is I've been advised, or also can see, this part of the hearing is being video recorded. Am I right, sir? Videoing? Yes? Could you identify who you are for the record, please? No? Well, I don't think we have a right to deny him right to record, despite the fact that I don't understand why you can't tell us your name and address.
Because
Something be withheld?
you're not allowed to.
I don't need to answer that.
Well, everyone should be aware that this hearing is being video taped and
Why are you
recorded.
allowing him to,
I'm sorry?
why are you allowing him to video?
I don't think I have a choice, that's
It's a
what, sir.
constitution.
I'm looking for
Without
the...
giving his name.
I know that, but I'm looking for the open meeting law, which
The right to
is
anonymity.
control. Give me a
Okay, I
second.
need one person to speak at a time, please.
Let me just dig out the open meeting law so I can...
It does not speak to this question, Mr. Chairman.
It's the
I think it's
Constitution.
right, I want to confirm that, sir.
Yeah, First Amendment.
Under the state open meeting law, to answer your question, which is a very valid question, it says, after notifying the chair of the public body, that's us, any person may make a video or audio recording of an open meeting, a session of a meeting or public body, or may transmit the meeting through any medium, subject to reasonable requirements of the chair as to the number, placement, and operation of equipment used so as not to interfere with the conduct of the hearing. At the beginning of the meeting, the chair shall inform other attendees of any such recordings. I have now notified everybody there are such recordings being made. I don't find that the one camera that's there in any way is going to disrupt the meeting. It would be nice if he could tell us, that's
What's the show?
that's Mr.
That's mine.
Parkinson's.
Oh, I'm sorry, I thought someone left that behind.
It would be nice if he could
You don't
identify
have
who
any
he is.
concern about who he is?
I don't think it's relevant, unfortunately, I don't think it's relevant. I mean, the fact of the matter is, all you need to know, and we need to know, is it's being recorded. I mean, unless he's going to put this on YouTube.
Oh, it does show up?
It might.
Oh, it does?
Even if he does, it doesn't mean we have, I think, have a right to prohibit it.
Can I have him move the camera to my good side?
I saw a hand go up, I'm not sure.
Hi. Sorry, Kim Courtney. Just wanted to note that the board itself is actually also recording this hearing.
With that, we do keep
I
an
just
official
wanted-
transcript.
Yeah, so you have to announce it anyway. Just wanted you to know, because it's
No,
recorded
I don't
by
have
the
to announce it.
stenographer.
She is our stenographer.
Right, so
All our
she's
hearings,
recording.
we take a complete transcript.
Yeah, no, I'm just saying she's audio recording, so just so you know, you already have to announce
Yeah, but she's
that.
doing it as an officer of the...
I know, but so you still have to announce it, because it doesn't matter.
But you already did.
I'm announcing to the world.
Just so you
This
know,
woman here is recording
it's important.
what's
Yeah.
happening.
What's
your name? Happy?
It's important to know these things.
Now let's get to the merits.
Rafferty.
It's more fun than what we're doing so far.
Well, good evening, Mr. Chairman. Again, James Rafferty, starring in tonight's production. My co-star, the man entitled to top billing is Louis Mastrangelo, seated to my right. And Mr. Mastrangelo is one of those Cambridge gems, a real icon. He grew up in Cambridge, a few blocks from the locus that we're here tonight on Putnam Ave, in a neighborhood called Greasy Village. And if you've been around Cambridge a while, the realtors have done away with any mention of Greasy Village. We have Huron Village, we have other Tony villages, but Greasy Village was a neighborhood where people like Mr. Mastrangelo and others, because of the predominance of the soap factories in the area, a lot of working class people. He has spent his entire life within a quarter mile of Greasy Village, except for the time he served this country in Korea and returned as a wounded veteran. He has an interesting business occurring at the property that's the subject of the application tonight. 269, 273 Putnam Ave, as the board, I suspect, is aware by now, is a lot that contains a two-family home, and next to that two-family home is an adjoining lot. It's actually all contained in a single parcel. But that lot, for years, had a commercial parking lot on it. Mr. Mastrangelo has lived and owned the property since the mid-1980s. And at the time he bought the property, it was an active licensed commercial parking lot. He reports to me that there were all types of commercial vehicles associated with some of the industry in the area that were using and were tenants of his for a while. Mr. Mastrangelo has been involved in the seafood business since he returned from the Korean conflict, in one form or another. He has worked and had a variety of businesses in the Cambridgeport neighborhood, but in the mid-'80s he became a wholesaler or a jobber in the lobster industry. He can share with you what that's about, but he essentially was involved in the wholesale distribution of lobsters, a process that involved spending most mornings at the fish pier, engaging, coordinating purchases, and arranging for the transport of those, the primarily lobsters, to restaurants and other venues. In the early 1990s, 1994 to be specific, he appeared before this board. Only the first time he was here a few weeks ago, you might remember, on another matter. But he's not a regular attendee at the board. But he did appear at that time because at that point he was operating his business out of a trailer in the commercial parking lot. It was his understanding that his property was zoned commercial, and he turned the commercial parking lot. He had a couple of trucks associated with the transportation of lobsters, and then he had a trailer, a box town, which he would have the lobsters delivered and then arranged. And he was essentially in the wholesale business. If you had an opportunity to read the transcript in 1994, he came to this board and asked for a variance to construct a new building to replace a garage that was at the rear of this location. The garage had fallen into disrepair. He demolished the garage and wanted to build a new structure. And he wanted to essentially put it on the same footprint where it had been before, but it didn't comply with the rear setback requirement. So he sought a variance. It's a rather simple variance, a short transcript. He identifies himself as a jobber and says he wants to get a variance to construct a building. And that building was indeed constructed in 1995. And since the time the building opened, it has been associated with the operation that Mr. Mastrangelo was involved in, the sale of lobsters.
Can I just interrupt you? I don't mean to, but my visual inspection of the property at drive-by is the business that's in question today, the retail seafood market and the restaurant. Is it being conducted not in the structure that was subject to relief? It's in the building. It's in the residence itself. It's a garage that's been converted into the seafood market. Am I wrong?
Well, you're right about where it's going on, but that is the structure that was the subject of the variance.
That's that home, which otherwise is a home.
No, there's a two-family home, and Mr. Mastrangelo lives there. And next to the home, and I have it on the map, and next to the home is a parking lot. At the rear of the parking lot is the garage.
Yes.
Now, the aspects of the business are occurring, and we're going to address that tonight. Aspects of the business have begun to occur behind the home. Principally, there have been picnic tables, and patrons of the business we're located in the garage have been sitting at those picnic tables. Now, those picnic tables are behind the two-family house lot. And as I became more familiar with the particulars of the history and this use and the concerns of some of the abutters, I sat with Mr. Mastrangelo and said it would be beneficial for him if we could narrow the scope of his request, because we recognize the significance of what's before the board, so that there could be some conditions offered for the board's consideration that would allow for some restrictions on this use. So if you saw the property today, what's there today is the two-family house, of which he lives in, and then next to the two-family house is the parking lot and the garage structure in the rear.
Okay, but you do acknowledge that the business that's operated today does not comply with use requirements of our zoning ordinance. It is a commercial operation. The variance that was granted in 1995 doesn't justify the conduct of the business that's being conducted today. If it were, then you wouldn't file for a variance.
I wouldn't be here if
You're
we
right.
didn't need a
So
variance.
there is, you agree that some aspect, and maybe we can put conditions if we get there, some aspect of the operation of that business, the restaurant plus the retail seafood business, is not in compliance with the use requirements of our ordinance.
Well, I can understand, that's a legal conclusion that I wouldn't take exception with, or I can understand the purpose. I think there is some question, and I would just say for the record, as to two things. One, the extent of the variance that was applied for, whether that variance provided the relief necessary for the use that goes on here now. Clearly, the department doesn't see it that way,
Right.
and we are here seeking a variance. And admittedly, I can understand, and I would only say that we're here seeking a use variance because the use that's going on there today is certainly not a permitted use under the current
That's all I
C3
want
zone.
to get clear.
Right, that's all I want to say. Couldn't agree further. The history, the fact that the zone was changed from office, what are the rights in the variance, what are the issues, we still have a potential issue as to whether there's an enforcement limitation based on other issues, but you're correct. The property today, that stretch of Putnam Avenue, since about 2000, is zoned Residence C3, and a retail use is not a permitted use in that district. And we are here today seeking a variance to allow for such a use in a limited fashion to occur in a residence district. And I don't want to appear
I wanna make sure we're all
cute
clear.
about that or anything. No,
Okay.
that is why we are here, and that's the purpose for which we're seeking the variance. But like many cases, the history here is highly relevant because it is, frankly, an unusual fact pattern that this use has been occurring quite open and notoriously for more than 20 years at this location, which I think could lead many people to question, well, how is it that that's been happening? And why is it that when the relief was granted in 1994, a review of the transcript doesn't show any discussion, the word lobster or seafood doesn't appear anywhere. But, and I've asked Mr. Mastrangelo tonight to address that because I said to him, it strikes me that that's important because there had been an understanding on Mr. Mastrangelo's part that he will share with the board tonight twofold. One is that he'd received a variance for the building, but more importantly, he knew the property was zoned commercial. When I first met with him, he said it was commercial, it was zoned commercial. And it is somewhat of an anomaly that in our office districts, particularly the Office 3 districts, retail uses are not permitted uses. And it's for that reason, back in 1994, the Whole Foods Market was granted a use variance for a 60,000 square foot grocery store. That's somewhat of an anomaly because we have design guidelines that promote ground floor retail in office structures all over the city. They're the preferred active ground floor uses all through the MXT district, the district down in Kendall Square. What's been missing down there, the urban designers and the city's planners say, is the fact that the office buildings didn't have active uses. But this is historical, not to be present, but nonetheless, there was a time, and it continues to this day, that the particular office district didn't allow retail uses. I would say that distinction was unknown to Mr. Mastrangelo. And that can be borne out by the testimony he's going to provide regarding the rezoning. Because there was a rezoning of this stretch of Putnam Ave in around 2000. I was involved with it because I represented the owner of a building known as the Biorad building. It was then known as the Biorad building, a large brick structure, approximately 80,000 square feet, 100 surface parking spaces, 4 doors from this location. New owners had taken over for that, and there was an attempt to put an addition on there and expand that building. And there was rezoning undertaken, and the property was rezoned. Excuse me.
No,
Yeah.
I don't mean to interrupt you. When you finish your thought, I want to ask a question. Go ahead.
So at that time, and roughly in the year 2000, or a year or two after, maybe as late as 2005, that stretch of Putnam Avenue was rezoned from office to residential.
Then why isn't this a legal non-conforming use? If in 1994 you started your business and it was proper under the zoning in 1994, and then in 2000 the zoning changed, made it improper, quote unquote, why isn't this a legal non-conforming use?
Well, because I think others would take exception as to whether it was proper in 1984,
Okay.
because the office use, as I stated, didn't allow the retail use. That's why Whole Foods needed the variance. So even though it was office, retail wasn't permitted. And what I was pointing out is that's a bit of an anomaly and is not consistent with the city's land use policies, but that happens to be, to this day, an ongoing
Yeah,
situation.
but that's a decision of a prior board, and if they got it wrong, they got it wrong, but it doesn't necessarily mean that we should grant relief. To me, it's not persuasive that we should grant relief in this case.
No, and it's not being offered for that purpose,
Okay.
to be clear. What I'm offering is, I wanted Mr. Mastrangelo to share with the board his understanding and to be able to address the question as to how did this use continue for this period of time, and why was it that it occurred? And the short answer is that when the property was zoned office, Mr. Mastrangelo took that to mean it had commercial zoning, and the relevance is that when the rezoning came around, he will testify later at the hearing, that he was approached by people to say, you should push back on this rezoning. They're going to change this to residential, and your business is going to be in trouble. And he said he asked around, and he was told by some of the proponents of the rezoning, don't worry, existing businesses will be grandfathered. So when the rezoning from office to residential occurred, and that's the reason I offer this, which again happened quite openly, it occurred with his understanding that he had a commercial use and that his business would be grandfathered. He didn't seek legal advice at that time regarding that, but the reality is that zoning, while it was commercial in the broadest context, retail was not a permitted use.
But let me ask you a question. You asked around the neighbors and they gave you this curbside legal advice. Did you ever think to call inspectional services department and get the answer from the people who know?
No, I should have been a lawyer, but
No, you're not a lawyer. You're just going to pick up the
Well,
phone.
can I just stop right there? The notion, when I say he asked, I wouldn't limit it to curbside legal advice. I think his discussions with me are that he talked to a number of people, including counselors and others involved in the petition.
Did
and
he ask
other-
the inspectional services department? They're the ones who enforce the zoning code.
I suspect not.
No. Okay.
No.
Okay.
But it's interesting because, well, Mr. Mastrangelo has a long history of engagement with the Inspectional Services Department. He gets inspected twice a year by health inspectors from Inspectional Services.
Yeah, but
He-
you're well aware of this, Mr. Rafferty is a very experienced zoning lawyer. But the philosophy of the Inspectional Services Department is they enforce the zoning ordinance by complaint. They don't go out, and let me just finish, and then you can go back.
Well, I think that's a little unfair. I think they
Well,
do it more than by.
I generally, we have this with the beekeeper's case over on Magazine Street. If people, and there are many people who have bees in this city, and the inspectional services doesn't go around and send violation notices. But in that case, a neighbor or neighbors complained to the inspectional services, and they looked into the case, and they found, in their opinion, there was a zoning violation, and we upheld that. Similarly here, if no neighbor or citizen of the city complained to inspectional services and said, hey, that guy over there is running an illegal retail business, it's a violation of the ordinance, they're not going to go out and I think it's to their credit, they're not going to go out and seek problems. They're not zoning police. I think that's very good. If people in the city don't like what someone's doing, they'll look into it and make a determination. If people in the city don't complain, they're not going to complain. And I think that, my guess is, pretty guess, that's behind the fact that this business has been operated for all these years without anybody doing it. Now there's been a complaint, and I don't want to get into who's made the complaint and why, and whether the complainants have clean hands or not. I'm not going to get into that. That's another day. But that's the fact. You got to take that. You have to understand that. You understand it. I think the people in the ordinance have to understand that. Is that it's not inspectional services are sitting on their hands. They respond to complaints. And there was no complaint, at least up until now. And that's why this business has continued.
I agree. I think the only reason, and I apologize to interrupt, I was going to say that I think that their vigilance in enforcing the zoning ordinance is a little more aggressive than simply sitting back. I think if an inspector is mindful of something, but I understand it is there's a large element of the enforcement division that is complaint driven, and I agree. And It does have some relevance. When I say it has some relevance, because the history of the zoning, and as I said, because one of the issues in law and in equity addresses issues associated with clean hands. And if someone is knowingly doing something they shouldn't be doing, and then they're later caught, and they come in and they ask whether it's administrative relief or other forms of judicial relief, the doctrine of clean hands and whether or not someone, we're going to reward bad behavior is a public policy I recognize is not favored. But there is some relevance to the history of the use, the length in which it has gone on, the fact that it was previously zoned commercial, and the applicant's understanding that that commercial activity was protected when it was changed to residential. And I offer that not as a dispositive argument associated with tonight's application, but as context for the understanding and thinking of the operator, who has lived in that location, continues to live there, and has operated his business there for 20 years. So that brings us to tonight's case and the issues associated with it. And it is a case for a use variance. And of course, we're mindful of the burden applicants for use variances face under the law. And there has been some guidance or direction. First, only some municipalities, and the state statute requires it, allow for use variances. And in our case, use variances in our zoning ordinance are permitted, as the board knows. So the fact that the ordinance grants the authority for the issuance of use variances suggests that the drafters of the ordinance recognize that there could be occasions when that would occur. I simply raise the issue about what's happening or what happened on Western Ave, not to suggest on River Street, with the Whole Foods variance and the retail activity there, not to suggest that that's somehow a binding precedent upon this board. But what the case law directs the board to focus on, particularly in matters involving non-residential uses in residential districts, is whether or not the proposed use, and I'm quoting now from a case, would unquestionably alter the essential character of an otherwise residential neighborhood. And tonight, our case involves evidence that we will submit to you that the board should be able to take personal knowledge of, I'm sure in most cases with most board members, of the character of the street in which this use is located. And this use is located within a few hundred feet of a large grocery store, which was granted a variance, but it suggests that it's perhaps not otherwise residential. There are, within less than 50 feet from this location, right across from this location on Putnam Avenue, that portion of the street is zoned Business A. And there are restaurant and retail uses there. And as I noted earlier, there's an office building, 4 doors down, 80,000 square foot office building, 4 doors down from here, which obviously, all of which, that in particular became non-conforming when the zoning was changed. But the most immediate and adjacent use here is also not a non-residential use. There's also a commercial use occurring. It's a bed and breakfast. Now, it was said earlier, we're not going to get into that. I would respectfully say the character of the surrounding uses is highly relevant for the board to be able to reach, as the court directed boards to do in the Boston redevelopment case, a finding to take into consideration whether a variance should be granted involves consideration of the proper uses in existence in the area in relation to the specific new use proposed.
You obviously, I've read your letter, and I haven't read the case, but I've read your quote. But I mean, here's my problem with that approach. What that means is that throughout the city, if you live in a residential area that's close, in the vicinity of a business area, or if there happen to be some non-conforming business uses in the residential area, you can establish another non-conforming use. We can blur the lines, the use lines. For example, suppose someone across the street from you wants to open up a retail store. They have the same argument you have. You're close to on terms of in the vicinity. You're very close to the Whole Foods and the 80,000 square foot building. What do? We grant the variance here, and we keep walking up Putnam Avenue.
Well, with all due respect, Mr. Chairman, I think that analogy is seriously flawed. What the court has directed boards to do is to look at surrounding uses. So under that analysis, it doesn't suggest, again, that that's dispositive. But one would say if the board looked at a street like Andrew Street, which is on the other side of Putnam Avenue, appearing on this map, which contains nothing but residential uses, the board could very readily find that, but for the changed use, this is an otherwise residential area. And that's what the court directs the board to do, not to say, oh, look, it's like horseshoes, if you're close, you get the use. That isn't what's being argued here. What the courts direct boards to do in use variances is, okay, examine, look at the record, and examine what the other surrounding uses are. And that can be a factor in a determination here, because one of the things you need to be able to conclude is the impact that this would have. So, Andrew Street, Fairmont Street, totally unaltered residential uses, one-way streets, streets without parking. The characteristics of this street, this section of Putnam Avenue in particular, the heavy traffic on the street, the history of commercial parking, the adjacent uses, 4 doors down the office building, the other side of River Street, retail uses, those are characteristics that allow the board to make a determination as to how this use might affect those other uses. And that brings us very quickly to the adjoining use. And the adjoining use in the abutting property, and it's not a question of whether someone's doing anything. I'll put aside for a moment the legality of that situation, but it cannot be disputed that the owner of the adjoining property, and this adjoining property is in very close proximity to this use, is a bed and breakfast. And if you go on the internet, you can learn all about that bed and breakfast, and we have regulations around bed and breakfast and regulations. But I found it striking. There are 31 reviews on TripAdvisor for that use. And if I was the proponent of that, one should take great pride in every review is glowing about the manner in which the business is conducted, the attentiveness in which the innkeeper maintains her property and is accommodating to a host. But nearly every one of the uses, the reviews, ironically,
That's not relevant.
it's highly relevant. With all due
Not
respect,
relevant.
we're
Not relevant.
establishing a record around the character of the surrounding uses. So
The fact of the
I'd
matter
like
is
the
that-
opportunity
that-
to put that on the record.
That bit was fine, that business that you're piggybacking on may be also an illegal use.
I'm not piggybacking on the
Well,
use.
yes,
That's
you
an
are.
unfair
You're-
characterization. I'm
you're just-
following the direction. But what the point I'm making, and I'll conclude with this aspect of it, nearly every one of the reviews of the adjoining bed and breakfast, and I'm not suggesting for purposes of this hearing that that is being operated contrary to any licensing or zoning law. I'll set that aside, agreeing that that is not a relative point of inquiry. But it is relevant as to what those uses are. So it's not within dispute. If you look at this map and you'll see, and you go and Google, that bed and breakfast is identified on these maps. That's a use that adjoins this property. And the point I'm trying to make is there are some assessments of that use. In of the 31 I could find, very low drama and quiet, very nice, quieter than most Cambridge places. Lovely garden to enjoy eating outside. So very quiet, comfortable and quiet. 31 reviews of people who stay in that bed and breakfast who comment about how quiet it is. So I'm suggesting there aren't too many use cases that come before the board where the use is already in existence. And there's a great deal of speculation and concern about, well, what will the impact of that use be on other uses? There's less speculation in this case because it's there. So understanding that, I did, and I knew I was very mindful, we won't pretend otherwise. We know where the complaint came from here. There was a 20-year relationship with this abutter. So we began to examine, well, what is it about this use that maybe we could impose some restrictions that would mitigate its impact on surrounding uses. Particularly that, because we were aware of that use. So I submitted to the board and sent to council for the bed and breakfast 4 proposed conditions. Which, the relevance of the conditions, if you understand the site, is to take any activity associated with the restaurant and limit it to the area where the garage is, if you will. So to separate the 2-family house, the backyard of the 2-family house, which is most proximate to that use, and say, okay, and then let's understand the nature of how you operate. I think the reason people who stay at that bed and breakfast can make the favorable comment that it's quiet is that this use stops operating at 6 o'clock. There's no nighttime activity. Ironically, the office use allowed in the variance could go much later. It could go well into the evening, as many offices do. It has the parking for that use. So there are many aspects of this particular use that are highly compatible with the surrounding residential uses. And what you're going to hear tonight from live testimony of neighbors and residents is the fact that they find this highly compatible, and that this is a resource for the community, and this warrants the granting of the variance. So I conclude by asking if the board will allow Mr. Mastrangelo to just give you his personal history.
I wanted to do that. I just have one question for you, though, different than the ones I've been asking. Why did in your opinion, or your knowledge, why did the city rezone this residential, this area, with all the commercial activities you identified? Why is it, now, obviously the city council decided they want this area to become a resident, be or become a residential area. So why, and if we were to grant the variance tonight, we would be going contrary to what the city council wanted for this area. Do you have any idea why did they zone this business, since with all the other business activities nearby? Why? Do you know? If you don't know, you don't know.
I know how it came about. I know there was a citizen petition that was filed. I know that zoning is a legislative exercise. And I know that when...
There's a citizen petition to zone it residential?
Yeah, that's
Okay.
how it started.
Okay.
I mean, it was not a planning board petition. It was not as a result of any planning study. It came about as a result of a citizen, a registered voter petition. And it came about and surfaced at the time that the building, the Bio-Red building, was sold, and the new owners were proposing additions to the building. I represented those owners. There were two efforts undertaken to constrain any expansion there. There was a petition filed by some of the same people to landmark the building, which the Historical Commission accepted the petition, and in fact did make this building, that building, a landmark building. But as to what motivates elected officials to behave in a certain way when faced with citizen petitions, I suspect the opinions are as varied as one's view on government participatory projects. But I would say that, from my direct involvement in this, I never heard any suggestion, and I would stand without fear of contradiction, that anyone who ever spoke in favor of rezoning this section of Putnam Ave cited this use as something that was in conflict with the goals of that petition.
No one who wanted...
No one who petitioned,
Got it.
either at public hearings, and as you know, hearings are held at the planning board and at the ordinance committee and ultimately the city council. This was a very hotly debated petition. It had everything to do with new ownership and the ability to expand. Because when it was also zone office, there was also dimensional opportunities available that didn't exist. There used to be a member of the planning board who used to require, before the planning board acted on rezoning petitions, Fred Cohn, who spent many years there, he would ask the staff to do a land use analysis and determine how many non-conformities would be created. And he had a general rule that if more than 50% of the properties became non-conforming, we have to be very cautious about rezoning it. So in this case, there was no analysis done, I can tell you from personal engagement. There was a desire to prevent an expansion of that building. So that building has come into new ownership. It's been refurbished. It's being used. It's used as an office. But from a financing perspective, from a land use perspective, there's now an 80,000 square foot office that is a non-conforming use. And if you write zoning opinions for lenders, it's not a great place to be. And the owners of buildings don't like to see that happen. But that rezoning did in fact occur, and as a result of it, that's it. But I would say that if the city felt that way, that once zoning is in place, use variance shouldn't be granted, then Section 10 of the ordinance would not give this board the authority to grant use variance.
Sure, but again, then we're moving back. But the fact of the matter is, the courts have said that communities can allow use variances. However, they're to be sparingly granted. They're very Brendan usually can cite the case, and you said it earlier in your presentation. It's difficult to get a use variance as compared to a structural variance. And that's,
I never used the word difficult, but I did acknowledge the burden placed upon the applicant.
okay.
But, and sparingly indeed, I mean, we haven't rushed here, we waited 20 years before we got here, so. We're very mindful of the fact that one shouldn't come here too often to see such things. But here we are, and we are so happy
And this
to
first
be
gentleman is dying to talk, and you've been hogging the floor, so let him speak.
He doesn't come here that often, and I may have to explain that he shouldn't be alarmed by comments of the chair regarding my presentations. That doesn't reflect fully on our position at
No,
the
I know.
moment.
I respect,
Maybe later in the evening, but at the
I
moment,
respect Mr. Rafferty as an attorney.
I say this, I appreciate that.
But I have to push him.
He's right. So Mr. Mastrangelo would like, and I've asked him to do his best, and he's here to tell you a little bit of his.
Yes,
Please, sir.
we took the liberty to write this down
Go
because
ahead.
I'm not very good at
That's
keeping
okay.
things in my head.
That's okay.
I'm Louis Mastrangelo, and I'm a lifelong Cambridge resident. The only time I left Cambridge was when I was in the service. I served my country from 1954 to 1957. I am a disabled veteran, and I have been in the seafood business most of my life. Starting as a young man at my uncle's fish market. I was a commercial fisherman in the 60s. And in the 70s, I owned and operated a restaurant on Pearl Street in Cambridge, selling fish and other foods. And I have been at 269 Putnam Ave since 1986 and purchased the property in 1994. When I bought the home, the parking lot was used as a commercial parking lot. And I've been working out of a trailer there and buying and selling lots, brokering them, doing a lot of that. In 1994, we applied for variance so we could build a structure that would accommodate my existing and expanding business. I have had a state dealer's permit, a retail store from the Commonwealth of Massachusetts Department of Marine Fisheries since the 80s. I used to have a federal license too, which I gave up. In 2000, I heard about the petition going around, rezoning in the neighborhood, and really didn't pay much attention to it. I hate to say it, but anyway, I didn't pay much attention to it. I did attend one meeting, and when I inquired about it, I was told that I was grandfathered in because I hadn't been here so long. I employed 5 full-time employees, including a manager who is a Cambridge resident. I feel my business is an asset to the neighborhood, providing a local owned and operated business with a unique product. Many of my customers can walk or bike to our establishment. We have 2 hotels and a multiple business within walking distance, including Peabody Terrace and 808 Memorial Drive. My attorney and I have come up with 4 proposals which we hope will be an olive branch to my neighbors. In my 20 years of operation, I was unaware that some of my neighbors had a problem until they went to an attorney, which brought the matter to the city, which brought it to me. All he ever wanted was to get along. Thank you.
Thank you for your presentation. I mean that. Anything else you want to say before?
No.
Questions from the board at this point? None? With great trepidation, I'm going to open this matter up to public testimony.
Since you raised the issue,
Yeah. Just an extra copy. What is it? Extra copy of those restrictions. They're in the file, but I'm not going to try to find it.
but we always tend to somewhat rely on Mendoza versus Licensing Board of Fall River, 444 Mass. 188 208 2005. The court language. Although all variances are unusual forms of relief from zoning requirements, use variances should be particularly extraordinary because they inherently undermine the local zoning ordinance division of uses. So that's the hurdle that
That's a hurdle.
we really have to get over. This is the existing, the previous case.
Or the previous. Okay, ready to go. I'm gonna have public testimony. I'm gonna ask those who are in favor of the release to speak first. May I ask us, we have a very big audience, I suspect a lot of people might want to say things. Please, if someone has made your point before, don't make it again. We get it. We don't need to hear it twice or 3 times. But I do want, you're citizens of the city and you took the time to come down tonight. So if you do want to say something, say it briefly and try not to be repetitive. The same applies to those who are opposed, who I will take next. So let's, I'm going to try to get an organized discussion here if we can, or at least presentation. So anyone in favor of the release, granting the use variance, anyone want to speak in favor? Okay, I'm going to take them in random order. Sir?
I've been,
Name and
I'm sorry, David Albert, 48 Ringe Avenue in Cambridge. Because of where I work in Cambridgeport, I've been driving past the Alive and Kickin for over 10 years, and it always feels like it's part of the business district there. You know, you pass the big corner with all of the stores, and you're still in the business district. It never felt like it wasn't. We stopped there. My wife and I have stopped there frequently for the amazing lobster sandwiches. Thank you. They meant a lot to us at various times, including when we had some illness in our family, that we were able to stop there on the way back from the hospital district. I'm still in there at least a few times, a couple times a month, getting the lobster sandwiches. I think that removing this is what would be the detriment to the neighborhood. I think having it there is a clear asset to the neighborhood.
Thank you.
Thank you, sir.
I'm Charles Hennebree. I lived on Columbia Street for many years, and I moved about 2 or 3 years ago, as you know, to Andrew Street, just a few blocks from this.
How do I know?
Because we were in front of you
Were you really?
about 2 years ago.
How quickly we
I have a close relationship with you. I thought you'd remember. I'm actually hurt. But Alive and Kickin has always struck me as a strange gem as you drive down Putnam. The area has become much more retail oriented since the appearance of Whole Foods. But I love the strange curiosities and the wonderful food once I started going there at my wife's insistence. So I'm an enormous fan. I do not feel that it hurts the fabric of that neighborhood, of which I'm now a loyal member. But rather, it's very, very close to a bunch of restaurants right there on River Street, and it's a strange curiosity, as I say. And the strange curiosity is what makes Cambridge a wonderful place to live.
Thank you, sir.
Yeah, my name is Patrick Barrett. I live at
Come a
2.
little
You need
closer.
to come up to the stenographer.
Okay. Is this close enough? My name is Patrick Barrett. I live at 234 Broadway, and my wife and I are currently building a house at 41 Pleasant Street, a couple blocks down the street. We're in the BA3 district, which is part, I think, of this rezoning. And in 2004, when it was done, it was highly contentious. I had to go back and look at the minutes for my own case. And part of the impetus behind the rezone was to create a neighborhood business district and to protect some of the residential areas. When this was done, one city councilor who's on the council now, who was representing Harvard at the time, called the change draconian. I think that actually speaks to your point, sir, about the issue of trying to undermine the purpose of the zoning ordinance. I think that we have all these mixed uses put together, and we have a rezone like that. It's so wide sweeping, you create all sorts of problems. And all the businesses along Western Ave are really non-conforming. When they switch hands, you're going to have all kinds of problems. And just as a side note, my wife and I are building a house in this district because it is mixed use, because we like to be able to walk to places. And I just kind of discovered this business like 6 months ago, and their lobster sandwich is amazing. To me, I think my property value goes down when they leave. That's all I have to say. Thank you.
Thank you, sir.
Thank you.
All right, this woman, yes, ma'am.
My name is Laurie Taymor Berry.
I'm sorry, Lori,
You're gonna have to
what?
come closer.
I live at 164 Pleasant Street.
I'm
It's
sorry,
about-
you have to
Yeah.
say it.
Okay, I live at 164
No,
Pleasant Street.
your
My name
name.
is
Your-
Laurie Taymor Berry.
Harry?
Berry, B as in boy, U-R-R-Y. Okay, Okay. I live maybe about 2.5 blocks from Alive and Kickin. It's a nice walking distance. And I must say it's the best fish. It's fresh. You know it's fresh. It's more affordable than some of the other markets in the neighborhood. So I would be very disappointed because we go there about 3 times a week. It would be a major, major disappointment and loss to the neighborhood and my family. Thank you.
And address again? Address again, because I missed it.
164 Pleasant Street.
Thank you.
Sir, come forward, so just make life easy for everybody. Whichever way, but just come a little closer to the...
My name's Dave. I live at 113 Hampshire Street. I worked for Lou at Alive and Kickin for a few years. And the point was brought up about exceptional circumstances. I don't know what that means in terms of the law. I'm not like a lawyer or anything, but for a business that was started 20 years ago by a guy who just loves what he does, it's been in Best of Boston, Phoenix Magazine, Chronicle. It's been nationally syndicated TV shows like Man vs. Food, American Idol. And in terms of exceptional, the passion that he runs it with is exceptional. And in my 2 years there that I worked there, I saw people from all over the world who have heard about it and came and wanted a chance to speak with him and get a chance to see what an authentic Cambridge business is in a time full of chain stores and retail stores that are funded by multinational corporations. We have a local neighborhood guy doing something extraordinary. So that's all I want to say.
Do you want to give us your last name, please? You just said Dave.
Yeah, Matt. I know it sounds fake, but
Matt?
yeah.
M-A-T-T?
Yeah.
Sir, please come forward.
My name is Richard Morrell. I live at 21 Whitney Ave, Cambridge, Mass. I have known Mr. Angelo since he was 10 years old. That's a long time. He's always had a business mind. When we was kids, we went to MIT before it got big, jumping, grabbing rags, grabbing bottles. And this man has always had a mind for business. He's a very good businessman, very good friend. And I hope the petition goes through.
Thank you, sir. Ma'am, you're right. No, yes, you. Yes, you. No, you.
I'm Susan Strasberg. I live at 431 Putnam Ave. In order for me to get home, I have to drive by Alive and Kicking every day. I buy it probably 3 or 4 times a day. And I find myself looking in every time because Lou is an entrepreneur, is sitting there, greeting all of his customers, making sure everybody's happy. And he's a prize for the neighborhood, and it would be a great loss to all of us because we walk there. Our kids can walk there, and it's quiet. You know, I've been there when there's a line out the door and saying, I can't wait this long. But there's never any rowdiness, there's never any noise, never parking problems on the street. He's a very good entrepreneur, and we need him in the neighborhood.
I saw a hand raised up. Someone's over there. I think that's wrong. Anyone else wish to speak in favor? Sir?
My name's Rocco Mastrangelo. I'm Lewis's nephew. I live at 850 Avenue D in Beaumont, Texas. I grew up in Cambridge. I'm a local 40 boy. I've been in front of this board many times previously for the local 40s petition. Lou and I kind of grew up together. This is like my brother. And we were in business together on Pearl Street when he had the little shop there. And this is his lifeblood. This is a Cambridge resident. This is someone who's been here his whole life. And to take something away that's that meaningful to this man, he'll take his life away. I'm telling you that because I know. So I'm disappointed at what's going on here so far. We've been here for a long time. I built that building on my license. So when we built it, we brought everything in. People were okay with it. We were happy. Things were good. And now all of a sudden, 20 years later, this thing fell. And I think that's a disgrace.
Thank you,
That's
sir.
all I got. Thank you.
I did see another hand back. I saw that hand there first. Am I wrong? Diane.
Hi, I'm Kim Casey. I'm from Medford, Mass. I've been here for Texas for as long as I can. I started the online petition. I don't know if you've had the chance to look at it. Okay. I can't even tell you how incredible it was to see the amount of support that is out there, not only in Cambridge, not only on the street, but across the world. And I was very upset, finding out that he was going through this, because I know how much he cares about. It's not even for himself. It's for the public, and it's for his customers and for his employees. Those are the people he cares about at the end of the day. So when that petition got, I'll never forget, we got over 1,000 signatures in under 24 hours. And if you read every single one of those comments, they're just amazing. And I wanted him to see that. And at the end of that petition, what it says is, no matter what the end outcome is, that we all say thank you so much for what you've done for the community. Because you brought people into Cambridge. People come to Cambridge, not for, the stores they end up going down the line, later that day. They come there because they see him and they know how fantastic it is. He's an exceptional person.
Thank you.
Oh, and I'm not, he's my uncle, not by blood. Not by blood, but by choice. That's right. That's right. No blood here. We love you.
Anyone else wishing to speak in favor? Sir?
My name is John Berry. I live at 164 Pleasant Street. I've been a resident of this community for going on 45 years. This business and this gentleman represent something that's being lost in a large part of America. The small independent businessman. This community has been overrun in recent years by big corporations coming in, taking over large sections. And quite often, they don't stand with the community. Those, if they don't make a quick buck, they're gone. This man's been here for us, and he serves us. It's a piece of the community that should not be lost.
Thank you. Thank you. Thank you. Anyone else wish to speak in favor? Yeah.
So my name is Laura Callahan. I came all the way from Havel for this. So I just wanted to say that not only does Lee help in the neighborhood, but he also buys bread fresh every day from Central Bakery in Cambridge. He buys farm fresh eggs. He buys local seafood. So he's helping himself. He's helping other businesses around. It's not just Alive and Kicking that is profiting from here. It's a lot of other businesses as well.
Thank you. Thank you. Anyone else wish to speak in favor? Going once, going twice, no one else. Now I'm going to turn to those who wish to speak in opposition to the relief being sought. Anyone wish to speak in opposition? Sir?
I'll move so everybody can hear me.
As long as the stenographer can hear.
Oh, yeah.
No.
Don't sit behind me. You can sit right here.
I'll just turn the chair a little bit. Good evening. My name is Neil Hartzell. I've been before you gentlemen before. I'm a lawyer in Boston. I hope you don't hold that against me. I'm not from Cambridge. But I come here often. I represent Ms. Sarah Smith, who's one of the abutters, and wanted to just address a few points that I don't think have come up in tonight's hearing. I'm listening to all the people in support, and I think it's wonderful. Mr. Mastrangelo a good business that's been successful. That's what America's all about. We've all read stories about the businesses that started in the garage, and they got so big and successful, they had to move to other states. Doesn't mean they're going out of it. It means they're so successful they've moved to another place where they can do more business and be more successful. And that's the situation that we have here. Apparently there was only one person who spoke in favor, who lives on the street, and I believe that person is not an abutter. We have a letter that's been submitted that's signed by, I think at least 13. I have another signature that I'll hand up to you when I'm finished. And I want to explain what's happened over the years. It started off as a very small, nondescript truck selling some lobsters back in the 90s. When it was zoned, not so much, well, it was zoned for office space. That's what the original zoning was, not retail. There's a significant difference. And then there was a rezone to residential. Perhaps he didn't understand it. So be it. But what happens over time is from the truck starts the business in the garage. And then it starts expanding. And the reason why we're here today, and I know some people are upset about this, is because it's expanded so much and it's become so successful. There's a constant line of people coming in and out of the place. It's going on all year long. It's going on every day. There's a fan venting out cooking smells in the back that wafts over the neighborhoods. There's, the fan makes a lot of noise. This isn't scientific, but we had the noise registered, and we believe the noise exceeds the zoning ordinances. For industrial, not for residential. It far exceeds residential.
Have you filed a complaint with the, not with this board, we don't, there's a noise ordinance.
Right, not yet. So this info just came to me within the last couple of days. We have garbage flowing on to the adjoining property. We have the loudspeaker going on from the time it opens to the time it closes, calling out orders. This can be heard through the house with the windows closed. With the expansion of it onto his house area, there's picnic tables right outside the dining room window. I mean, literally just feet away. There's been new structures built that we believe don't have building permits. There's a new roof, there's a new roof area, and we have some pictures that have been submitted, right up against one of the abutting property lines. And it's been enclosed. They're winterizing. And there's no, I think it's in complete violation of the setback. And I've been told the building inspector is taking some action on that, but I don't know what that is.
That's not relevant to the use variance question.
No, it's not. But
If there's an issue on that, that's a separate case and a separate matter. So that's not relevant. I don't want to.
But the point is that what's happened over time keeps expanding. Now there's nowhere for it to go. There's sheds in the back of the building that also violate the setback ordinance. Same issue as you just said. But my point in telling you that is, it's the growth from the small, nondescript garage and supposedly office to full retail, multiple employees, customers all the time, noise all the time. Again, a victim, if you will, and why we're here tonight, of its own success. We don't want the Lobster company to go out of business. We believe within walking distance, there's alternative sites. There's a site on River Street, we're told. There's a site near the Whole Foods. There's some cafe that went out of business that I'm told is unused. I haven't looked at it myself, but that's what I've been told. And I don't want the board to have the impression that the abutters won't shut it down and put this hard-working guy out of business. We just, what's happening? Why do you have zoning laws? They pay their taxes just like everybody else. And because of the success of the business, because of the noise, the disruption, the garbage flowing, it's just become intolerable. That's why we're here tonight. Years ago, we didn't have this issue. Social media, Yelp, all the reviews, it's great for his business. It's not good for the neighbors.
Thank you. Anything further?
No, that's it.
Okay, ma'am, I'll call you next.
Can I address something that he said?
I can't cross-examine him. I don't want
I
to.
know, but I just want to make it clear. I'm a realtor, and
Yeah,
finding
give me your name too.
Susan Schlossberg.
She spoke already.
I spoke already. Can I speak again?
Wow. Yes.
I just want to say that it's very difficult to find any retail space in Cambridge. Okay, the Putnam Ave Cafe is not available. It's been closed down probably only 6 months after it opened. It's not available for any retail space. And I have clients who...
How do you know that, by the way?
Well, she's correct. I represent Whole Foods. That's used as a training facility. Whole Foods attempted to relocate their alcohol sales into that location, and neighbors opposed it. So years ago, Whole Foods, they keep the wine and beer sold upstairs, and they use that as a training facility for stores in the area.
So they have no interest in...
No interest. It's part of their store. They put it there as the cafe as an accommodation to the neighbors.
Yes.
Because even though it was an office district, the neighbors wanted an active use on the street. And
We had a zoning case involving that cafe after we wanted to shut it down. I don't remember what.
there was a case, and I was here. Just like that guy, you don't remember me. I was here that night. We needed to. It was still an office district, and we wanted to put a retail liquor store in the cafe, and we met with opposition. So,
while we're on the subject of other space, what about Western Avenue? There are a number of storefronts there that are not being used. And driving down, I can see that there's a new structure that we're rebuilt of the structure with residential above, and there's retail on the ground floor, and as far as I can see, no retail has ever moved in there.
There's a carrot over that. I don't know what that carrot means.
That's enough. I take the place.
Is that what the carrot is? I didn't know if there's a vegetable store coming. Seriously, I've seen this carrot.
Did you Southway Development in that space on the corner of Dodge?
Yeah, Dodge, right.
I mean, obviously, that is a solution, maybe not the ideal solution, but that is a solution. I have a second solution, but that's one solution. I haven't, if we were to deny the relief you're being sought, and you have to go out of business, you're not necessarily out of business, you gotta move your business first. It's not as
It
convenient.
has to be a suitable place, so you can't
To
just
be
go
sure.
anywhere.
To be sure,
Well, I'm not talking about people, you have, those
Sure.
types of business you have to go
Okay, anyway, second half of the question, my question is, have you thought about legislative relief? I mean, in the sense of rezoning this area to make this business legal. I mean, it wouldn't be, you're right, abutting or near a business district, as you pointed out, we all are aware. It wouldn't be a big deal. I mean, in the city of Cambridge, the city council, in their wisdom or lack thereof, have made this a residentially zoned area. Someone has decided, as a council, they want to make this area residential. If it's not residential now, we're going to push it into residential, except for the extreme cases where we grant variances. What?
Mr. Chair, but that analysis ignores the fact that it's approved for non-residential use now.
But not for the operation.
True, but if the focus is this is supposed to be residential, the irony is there's a residential dwelling unit on the second floor, and that was the subject of a complaint as well by the same complainant in this case. But the issue here is not simply, I mean, the notion that, I agree, use variances should be given sparingly, but you have a report and a recommendation from an agency that's responsible for the drafting and commenting of the zoning ordinance, the planning board. Two of the members of the planning board served for many years here. They, I don't think, in making their recommendation, suggesting that the board act favorably upon this with appropriate conditions, were ignoring the admonition of the court to say that it should be done sparingly in extraordinary circumstances. They are not in the business of ignoring the intention of the council or the intention of the ordinance. I think that has an incredible amount of weight, worthy of consideration as the board conducts its deliberation. The fact that the planning board, statutorily charged under 48 and our municipal ordinance to be the chief planning agency for the city, is recommending that this is a use.
I will read that recommendation, the memo from the planning board, but my comment on that is that you're correct in your description of the conclusion, but I don't find it a ringing endorsement for the
I was present. I heard the testimony.
Well, I've seen the letter. Well, we have the conclusion.
I would respectfully suggest it doesn't capture the enthusiasm because because they had an opportunity to hear not only from me, but from Ms. Smith, who told them the reasons that she opposed it. So they had a full hearing on the matter.
I just simply say that I'm not sure their conclusion is more.
Well, on the substantive question as to whether that board would take a different view of the integrity of the zoning ordinance than this board, I think is somewhat unfair to them to suggest that they would be contravening, in making a recommendation, they would be advocating that you contravene land use policy in the city. They reached a different conclusion, that's all.
Anyone else wish to speak in opposition? Let's see, Mr. Brandon.
Thank you, Mr. Chairman and members of the board. My name's Michael Brandon. I live at 277 Pines Avenue. And my eyes are kind of watering from all the smoke in the room that's been blowing around. And I hope my friend, Mr. Rafferty, hasn't thrown his back out trying to put irrelevancies before you to distract you from the issues that are actually before you. The question of how good these sandwiches are, and my mouth is watering, it's all irrelevant. The family history, the proponents, that's great. I'm sure some of the homeowners are perhaps veterans and longtime Cambridge residents. None of that is relevant to what's before you. The things that are relevant, possibly, I think the arguments are being made before the wrong body. All this about the wonderfulness of the restaurant, and I believe it, and that's why it's so successful and grown so big. But that's an argument to be made to the licensing commission. I assume that there's a common victualer's license that,
I don't think the licensing commission, it couldn't, they grant a license to a business that can legally operate in the space.
so it doesn't have a
The
city
licensing board,
license?
the city council can, the body can go, they write the zoning ordinance. I believe that's the only body besides ours that could allow the restaurant to continue.
No, the licensing commission.
I don't believe that's the case.
Mr. Rafferty can explain to you that
Am I wrong, Mr. Rafferty?
they grant for sit-down restaurants.
Yeah.
Never in my experience. And certainly when contrasted with the legal analysis of the speaker, I would place all my confidence in your legal acumen.
So is Mr. Rafferty saying that
He's saying
that
in
the
a
license
very flattering
commission
way.
does not license
This is
common
not
victualers?
licensing
Can you get to the point, please?
Are we talking
This is
about-
going on too long. I can't stand this. This is not a dialogue between you and Rafferty.
I'm
You're
sorry.
speaking to the board, you're testifying now. Get to the point. What is your point?
My point is that if you want to talk about some of the things that are being talked about, such as clean hands, my question is the proprietor currently licensed for what he's doing? The reason for those licenses is the fire department comes and inspects, makes sure there's safe egress. I'm not familiar with the property. I don't know if the aisles are wide enough, if the fire suppression equipment, sanitary inspections are one thing. So I hope he's keeping the food cold and so forth. But there are other things. That's why it's there, to protect us.
Sir,
I'm not familiar with it.
let me speak. No, I don't want anybody speaking out.
Thank you, Mr. Chairman. And I'm sorry if I'm upsetting
Just
something.
get to Mr.
All right.
Get to the point, please.
So that's one board that the argument you've heard might be relevant. The other is the city council. They're the ones who established the zoning. The zoning is quite clear. If, and I've seen this board wisely, in my opinion, deny variances that weren't appropriate, especially use variances, you've told other applicants to go and try to change the zoning, and they've done it. The council has upzoned properties, several in Porter Square that I know of. The other thing is the precedent is, if you allow this, then why not, indeed, for the neighbor to open a hotel, as some people have disingenuously described it, by getting a variance. You're not here to rezone by variance. That's the council's and the planning board, and I understand if it was just 2 members, that's a minority of the planning board who may have said, put some conditions on it. And the council often doesn't listen to them. They just Monday night completely ignored a recommendation from the planning board. So I hope you'll follow your past approach. The other thing that Mr. Rafferty has not gone through is there are, as you know, very strict requirements before you can issue a variance, especially a use variance, but even a dimensional variance. And you worked very hard at this. I saw you earlier tonight struggling with it. And those, in my view, have not been set. There's no hardship here because the hardship, although I believe it was innocent, and he may not have known, but it was of his own making. He failed to call inspectional services. He failed to get an attorney. But the courts are clear, we can look at the case law that a hardship of your own making is not a legal hardship. The fact that the second criterion is the structure. And as I understand, he's saying the structure isn't conducive to his business. Well, his business is not legal in that spot. So that makes no sense to me. And then finally, does it derogate from the intent of the ordinance? The broad intent of the ordinance is to make businesses thrive and make residences thrive, and that's why we have zones. And to have light and air for neighbors and not fumes from. That's why it's divided that way. And in Cambridge, we're so compact that it's hard, well, should it be here? Or the rest of the district is business? Fine, go argue that to the city council, put a petition in. Are you going to spot zone this property, or are you going to do the whole street? I don't know, but that's where the decision needs to be. And as far as the public good, the public good is served by a really good restaurant and by entrepreneurs succeeding, but not at the expense of other people. And that's not good. And what's really detrimental to public good, in my opinion, is not abiding by the laws. You know, if the law says this, then, you know, that's it. You know, you change the law, but you obey, and you don't continue to operate when you have an order to shut down that's been upheld by this board and it's still operating.
Thank
So
you, Mr.
thank
Ray.
you.
Okay. Anyone else wish to speak in opposition? Sorry, stand in there.
Hi, my name is Ray Faulkner. And I live
Say it again?
Ray Faulkner, and I live at 11 Blackstone Street in Cambridge. And I've been here, I've had the sandwiches, they're great, I have nothing against the lobster sandwiches, I don't know if anybody does. But I live on the back side of him, and his van comes out to our parking lot and into our windows, okay? So if his diners were sitting in our parking lot, they would leave immediately, and they wouldn't sit there and eat that. In the middle of summer, when it runs all day long, then that smell permeates into our building. And anybody that lives there has to keep their windows closed. Okay? So it's a definite nuisance in terms of the way it's vented. It vents out the side of the building. It doesn't even go to the roof. I thought there was a requirement that vents go to the roof, but apparently not in this case.
Okay.
Okay?
Thank you.
And there's other residents of Blackstone that
You have a question?
have the same problem.
Yeah. How long have you been behind?
Since 1999.
Okay, and when did the impact start? I guess what I'm trying to do is find a timeline, you know, back as to when it became a full-fledged restaurant with the blowers, with the...
I don't know when he started serving sandwiches. I don't exactly know when that date was or anything else. The
But-
Lobsters have been there.
Yeah,
Okay, and I don't know
forever,
how long.
but I mean, like the blower and stuff like that. When did you notice that it was starting to become a nuisance? if you
I've
will?
noticed it all along. But the assumption was that people get permits to do things. And now I understand there's no permits. There's sheds that have been built right up against our property.
All right, so
No permits.
we're going back 15 years, is that what you're saying?
No, I don't know if it goes back 15 years. I'm just saying it goes back a ways. I don't know how far it goes back. But it's always been a nuisance, okay? But there's an assumption that people follow rules and regulations and get permits for things. Now that I know that there's no permits for anything, okay, including the sheds, including the business, including anything, this is a joke. It's ridiculous.
Thank you.
Most people have to abide by rules and regulations.
Yeah, would you have a business card?
Anyone else wish to speak in opposition?
Great, thanks.
Ms. Hoffman?
Hi, my name is Heather Hoffman. I live at 213 Hurley Street, and I just want to repeat one thing that I said in the hearing in the other case that involved this, and that is that the laws of the ordinances of the city are for the benefit of the public, and if the city, for whatever reason, doesn't enforce them, it is still the public's interest that has to be served. And so while I can say I'm sorry that someone innocently or otherwise fell afoul of them, it is not this board's problem, and it's not the city government's problem that the rules were not followed, because it's the public's interest that is to be served.
Thank you. Anyone else? Ma'am.
Hi, Kim Courtney. I'm a Cambridge resident and attorney, and I'm also the founder of the Food Business Association, and we have around 450 members who are local food entrepreneurs. Many of them are trying to open businesses right now in Cambridge. In order to open a business in a restaurant in Cambridge, and he does have sit-down tables, you need to get a commercial lease, which is expensive. You need to get a common victor license from the License Commission. You need to hire architects, you need to get permits, hire contractors. You need to abide by accessibility standards and fire standards and bathroom standards. That's all very expensive. So for 20 years, he's operated an illegal restaurant with an unfair market advantage. And that harms all of Cambridge businesses. So as much as I sympathize with his, if he would be required to shut down and move, I think that that's fair result for him to move. There are plenty of commercial real estate spaces. I'm aware of one at 1001 Mass Ave. So that is available, and he could move there if he wants to. Yeah, my main question that's been asked many times tonight is, why do we have zoning laws at all? Because if we pass this tonight, then I'm not sure why we have the zoning laws. I also haven't heard any discussion of hardship. I think that's the primary requirement. Mr. Rafferty hasn't pointed out any hardship. Operating an illegal restaurant for 20 years is not a hardship.
To that point, Mr. Rafferty did deal with that in his written submission. He chose to maybe overthrow.
I haven't read that, but I haven't heard it. And
his hardship is Mr. Brennan characterized it, is, and correct me if I'm wrong, is that if we don't grant relief, he'll have to shut down a substantial business. Or not substantial, a business that has been running for 20 years.
Right, okay.
Whether that's sufficient hardship is another question, but he has to address the question of hardship.
Yeah, well, from my perspective as an attorney, I don't consider that to be a hardship. And the supporters, that's great that he has a lot of support for his restaurant. That's wonderful. So when he moves it and opens up somewhere else, he'll have a lot of followers. And, but he'll have to comply with all the requirements that the rest of us have to comply with in order to compete in a fair market economy. And that's the way it should be. Thank you.
Thank you. Anyone else, sir?
Yeah, Xavier Dietrich.
Again, now I'm going to tell you your name.
Can you spell that, please?
Xavierdiettrich.
Thank you.
And I also oppose granting this, I'm a Cambridge resident also.
Address, please.
No, not required.
Yes, it is.
Everybody
So,
else is given.
Everybody's giving their address, sir.
Everybody to the city council.
I'm sorry, respectfully, Chairman, it's not a legal requirement.
It's not a legal requirement, but as chair of the meeting, I can impose these requirements. And I allow you to speak if you'll give us the address, your address. If you don't want to give us your address, you're not going to speak.
Okay,
You're not speaking. Anyone else wish to speak in opposition? Going once, going twice. I'm going to close oral public testimony. I've asked you some questions already, Mr. Any final comments? You addressed my questions about moving to another location or seeking legislative relief. So that's in the record. Anything else?
Right, well, two things. One is that there are 4 additional individuals, 2 of whom will live on Putnam Avenue, that were here this evening and were unable to remain, and ask that their support be entered into the record. There was some comment earlier. Just in summary, I think the board is appropriate in its high level of scrutiny when evaluating use variances. But if the case were that every time a use variance is given, then the legislative intent of the council is ignored or rezoning occurs, then it would not exist within the ordinance the authority for use variances to be given. And it is clearly within the authority of the board to grant use variances. And there are use variances in very close proximity to this use for retail operations. And I think the direction the board should follow is what the court said in the Boston Edison Company case versus the Boston Redevelopment Authority, that the board in use variances, particularly in use variances in residential districts, should examine the surrounding uses. As I said, it is not a case of if this use were not there, this would be a residential use. There's all types of options here. It's a highly desirable location. One could build condos, one could put up multifamily as a residency C3 district. I don't think that's the place the board needs to apply its analysis. I think the board needs to examine what is before them in the form of the application and what the variance seeks to do. The variance seeks to allow for a use to continue that's been there for some period of time. And the relevance of that has everything to do with the board's ability to assess the impact of this use on surrounding uses. Mr. Mastrangelo could speak for a minute or two to, I think, what was a very relevant question by Mr. Sullivan, because I had the same question. How is it that over such a period of time, this business seemingly peacefully coexisted with its principal critic this evening. And I've done my best to understand that. I've attempted to engage with counsel for the abutter to try to understand, well, what is it about this that we could return to a level of peaceful coexistence here? And I haven't been successful in figuring that out, but it came to me through third parties that the picnic tables are a more recent phenomenon. And I discussed with Mr. Mastrangelo, that's why I want to close with asking the board to focus on the conditions, that the restrictions are in place. And I explained to Mr. Mastrangelo that the board has challenged tonight because they understand that a use variance in this location would run with the land, so that it would be appropriate to limit the impact of this to the experience he has now. He doesn't serve breakfast. He doesn't open before 11. He closes at 6. Those are all conditions that you should offer to the board by way of consideration. Those are mitigating factors that the board ought to be able to evaluate. Because at the end of the day, the hardship does exist. The hardship is essentially related to the structure that is there today. The use of the park, it was a commercial parking lot. There has been commercial activity on that lot and in the premises for nearly decades, 50, 60 years. The odors that waft through the property are not from this use. Mr. Mastrangelo will tell you, the ventilation, he boils lobsters. There's no fryer later, there's no cooking. His testimony, his experience is right across the street on Putnam Avenue. There is a restaurant, popular restaurant, and like many restaurants, fumes, odors, aromas, not necessarily noxious, do waft across the property. It's not his aromas that are doing that. You might, can he just conclude with his own, because this, you know, this isn't a speculative venture here in the sense of, well, he's got all these other options. What you heard tonight was genuine testimony from people in the neighborhood speaking to the value of this. And that's what the commentary of the planning board was. I was there, and the planning board was also mindful. So if this were, and the law would suggest that understanding the difference, the impact a use has on the community is highly relevant for use variance. So if this was Panera wanting to have another outlet, or as we talked about earlier, if this was a purely residential street without any mixed uses on it, I think it would fail under the analysis that the court directs you to do. Look at the surrounding uses and understand its impacts. This is a very different situation. But as far as compatibility with other neighbors, I'd just like Mr. Mastrangelo to conclude by sharing with the board the conditions that you experience across the street. This isn't critical of that business, but that's where
They cook fish and clams, and any town in the northeast wind would breeze, it comes right through. It comes right through, it goes right past Mrs. Smith's, and in the back there. Any other wind, any other provision, all I cook is lobsters. We don't cook anything that, it's the smell of lobsters, that's all that comes out, and it dissipates almost completely. That odor comes from, they've had problems before, they moved their ventilators so the people next to them wouldn't smell that odor. And they fry a lot of fish all the time. I don't know, I supply them with the fish. That's all good stuff. But when you fry it, yeah.
You guys, I called public testimony, but you want to respond to the...
Yes, I do. The odors that I'm talking
Okay,
about...
I'm sorry, remind me your name again?
Ray Faulkner. The odors that I'm talking about are directly from his bed. They are not from across the street.
Okay.
They're directly
I don't
from
want to
his
get
bed.
too debated further. Thank you. I'm going to give you a chance to express your views.
Just one thing, I just want to hand up this letter that I referenced tonight. Just another signature.
Two things. One, I want to turn to the conditions that you proposed, which would be, if we grant relief, would be two things. One, I want to turn to the conditions that you proposed, which would these would be imposed on Mr. Mastrangelo, and see if the board members, before we take a vote, whether to grant the variance, are satisfied with these and want further ones. But I do want to make one comment. We have granted use variances before, generally in the area, but it's only because the structures, the retail use, you're absolutely right, it's only half the story. We granted it because there are structures that are only usable for business, and they happen to be in a business area, in a residential area, and that's why we granted relief.
Well, I'm not sure who the "we" refers to, but that wasn't the case in the variance that was granted for the whole.
That's many years ago. I'm talking about the current practice of this board. And just to be clear, we had a case on Western Avenue where in an area just like this, where a petitioner bought a residential home, wanted to convert it to an office, many businesses around, but there are also a lot of residences around, and we said no, because that doesn't justify a use variance. That's not your case. You made a different, compelling personal story, but in point of fact, we don't grant use variances that easily, and we do. It's generally because there is no other alternative for the use of the structure other than to grant the use variance. Anyway, I don't want to debate this further. The restrictions being proposed by the petitioner, or volunteered by the petitioner, should we grant relief, and what would we make the property subject to, are 4 in number. First restriction would be the use of the property as a restaurant with retail sales shall be limited to the ground floor of the accessory structure and the paved area surrounding it. 2, the rear yard of 269 Putnam Avenue shall not be used as part of the restaurant/retail use. Picnic tables will be removed and access will be restricted by a fence with a gate. 3, the business shall not be open to customers prior to 11 o'clock a.m. and shall close at 6 o'clock p.m., with the exception of Sunday when the business will close at 4 o'clock p.m. And 4, deliveries to the business will not occur before 7 o'clock a.m. So that is what Mr. Rafferty has been referring to. I'm not sure the members of the audience saw these, but that's what would be imposed should we grant relief. Okay, we do have tons of written commentary. I'm not going to read it. I'm certainly not going to read it. As Mr. Rafferty, well, let me start with the planning board. The planning board has written a brief memo to us, which I will read into the record. The planning board discussed the variance request to allow the retail sales and restaurant at the October 6th meeting. The majority of the board expressed the view that the retail is an asset to the community and supported favorable consideration of the requested use variance with reasonable restrictions to protect the neighboring residents from impacts from the restaurant use. Some board members expressed the view that without knowing more about the history and specifics of the case, they would leave the decision to the Board of Zoning Appeal without comment. That's the planning board's views on this case. Mr. Rafferty submitted a petition signed by someone who said 1,000 names in support, and then we got...
Can I ask you to enter on the cover letter accompanying that I've identified, because my cover letter identifies the number of residents on the petition, and there are 3 categories of petitions. I'd like the record to reflect
Sure,
that.
I'd be happy to do that. I should have done it anyway. The petition contains the signatures of 554 citizens who reside outside of Cambridge. Also included herein are the names of 2,040 individuals who expressed their support for this use online.
I'm sorry, you missed the first part of the letter.
Petition in support of the Alive and Kickin Lobsters. Yeah?
You started with the
Oh, I'm
500
sorry,
outside
that's
of
the
Cambridge.
sentence. You're right. Thank you. Please note that the petition has been signed by 1,264 residents of Cambridge. Thank you. I missed that. We also have letters in opposition, or petitions in opposition. I'm trying to find the petitions, so I have an idea how many people have signed. I think about, let's say roughly 15 people who have signed a petition in opposition. And they say they are strongly opposed, to summarize the letter, strongly opposed to the request for a variance, and I'm not going to go beyond that. I mean, the point being is there is neighborhood opposition to the relief being sought tonight. I think that's it in terms of what I'm going to put into the public record. Anything that's been in our files right now is deemed to be part of the record. So I'm just, because I'm not read it into the file, doesn't mean it's not being considered by our board. I certainly have read the file, and I'm familiar with the views expressed pro and con, and I'm sure other board members have as well. So with that, I'm going to close public testimony at last, and I think we're ready for discussion.
A couple of people that spoke in opposition alluded to the fact that you're operating without proper licensing or inspections. Can you address that, please?
The premises are inspected semi-annually or annually?
I think twice a year.
and they have a food handler's license, and they, and they are, the food handlers is issued by the health inspectors of inspectional services. The property does not operate with a common victuals license from the License Commission.
So that's another element of which you're not complying with the law of the city.
Well, I wouldn't go that far. That's a conclusion. Common victuals licenses have a variety of applications. If the food consumed on the premises is typically the standard as to when a common victuals license is required, and it's never been clear to me what the role of these picnic tables are. If someone were to simply operate a seafood market, even one that sold a lobster sandwich to the public, that would be a retail use which would not require a CB license.
But the picnic tables are there presumably for people who buy the food. I'm sure people from the other side of East Cambridge don't bring their lunch over and eat their lunchbox at the picnic table.
Not that we're aware of. But when I inquired about the picnic tables, I learned that the picnic tables were placed there and people tend to avail themselves of them. And so it's for that reason, frankly, Mr. Chairman, that I suggested that the picnic tables in that location be removed, because I do think that introduces a whole other aspect. And we were provided photographs of people at the tables and in proximity, and frankly, it was an attempt to say, okay, how can we limit this? What is the core nature of this business? And the picnic tables, I think the activity around the picnic tables perhaps has increased in the past few years than has historically been the case. I think the number of tables has probably increased. So it was my recommendation, which Mr. Mastrangelo accepted, is that that area no longer be associated with the operation.
And removing those tables will avoid any problems for a common victuals license, too, I assume.
I believe so, but I mean, we will definitely explore there. It's the same department that licenses tourist houses and lodging houses. They're very familiar with the area, so we will, I know there's been inquiries about them. So I think they're going to be looking at a lot of the uses here, both of this property and the adjoining property, because so it's suffice to say that I wouldn't want to say definitively, but yes, it's that aspect of the use that does trip over the CV. So
You, in your petition, you are asking for limited retail food sales and a restaurant.
correct.
That's the existing business. You want to continue the existing business, which is retail and seafood.
Right. So I suspect that, but just not in the back end.
Variance, and it became obvious to inspectional services that you needed common victuals license, that you would get it.
We would need to apply for that. Correct.
Yeah, well, I suppose we should, if the restaurant aspect of this is being pursued with or without picnic tables, then I think we should make that clear in the motion also.
Well, we don't
have to.
The victuals license, isn't that a licensing board?
It is, but if the relief isn't provided, the applicant couldn't apply. There's a zoning sign-off required of the license application. So to apply for the CB, the restaurant has to be an allowed use. So at the moment, it would appear the restaurant is not an allowed use. So that's why the relief speaks to retail and restaurant. It would then be a determination by the License Commission around the CB. So that's correct.
Yeah, would you be amenable to altering or beefing up your venting system?
Yes.
I'll have it checked out and see if there's anything wrong. The vent system, they just cook lobsters, it's nothing else.
I didn't examine the property, I don't know where it comes out in relation to the neighbors.
Can
it be raised up, you know?
I don't know. I don't agree with what. I don't know how it would
Is
frame
it
it.
vented through a hood system, or is it?
No, I don't. That's a good question. Mr. Scott's asking, is it vented through a hood system? How does the
Vented through an Acon ventilation system.
what does that mean? Is there so what do you it's
Just a little fan that just blows it out?
No, I have a hood in there, and all the hood picks up is the steam that comes off the lobster tank. I mean, the kettle that we cook the lobsters in. When You open the kettle, the steam is up, and you just put the switch on and suck the steam up. That's all there is. There's no cooking oil, there's no food.
I know it. What? Sir, please. Anything further?
No.
Yeah, George?
Yeah, I have a few questions. So, first of all, what are your hours of operation?
From 11 o'clock in the morning till 6 o'clock at night.
Okay.
Except for
Sunday.
Sunday to 4 o'clock.
Okay. And right now, I guess you don't make tons of money to move. Would it be a hardship for you to move somewhere else in Cambridge and establish the same business?
It would be a big hardship to do that. You'd have to have the right place, and you have the right facility, and you have to install tanks. It's got to be a big place, it can't be a small place. I got a small place right now, which complies with HACCP. And,
But if you have a small place now, why do you, if you move, why do you have to get a much bigger place? I don't understand that.
you have to get equipment, the way the equipment fits in there. You just have to probably get new equipment. And
Yeah. So, you're gonna do equipment, you may, there may be, obviously there's a cost associated with that, but you don't necessarily.
Plus, first of all, I want to own a new place. I don't want to pay any.
I understand that, but the point is that if we don't grant your relief tonight, your only alternative is to move your business, other than closing it down, move your business to a rented place, and that's a consideration for us to.
It wouldn't be profitable.
Wouldn't be profitable.
Because lobsters are very expensive, and I hold the county minimum in the public.
That's your answer.
Okay, and the other question I had is, you own the property that you're in now. So, the economics of this are bothering me, that's what I'm thinking about. Because for you to move someplace and just maintain the business as status quo, it will cost you a ton of money in Boston, in Cambridge. So, the other question I had, you mentioned that you were handicapped. You mentioned that you were handicapped also.
Yes.
Okay.
I'm blind in one eye.
So,
Deaf in one ear.
right.
Anything else, everybody, for discussion on the merits? Any further questions before we?
Well, just, he'll get along this thing. Just, how long have you owned the house next to the establishment?
It's a question to you, ma'am.
Yeah, how long have you owned the house?
I'm sorry.
Or council, or whoever wants to answer?
I bought my house 3 months before Mr. Mastrangelo bought his. I bought mine in February 1994.
Okay, and...
No, 93.
Okay, and how long have you been operating a B&B out of it? Since
I started.
Since the beginning?
Yeah.
So again, I'm sort of troubled as to, from 1993 up to 2015, apparently you have coexisted there. And yet I guess what we're finding is that the intensity isn't just a new phenomenon within the last year or two, it's been going on for a number of years. So I'm just trying to get an idea of where the tipping point was here.
Well, if I could address that, I'm sorry.
Sure.
What's happened in recent years, and I can't just exactly when, but things are just expanded. There's more people, there's more noise, there's more orders being called out on the microphone, there's more smells coming from the vent, and the customers are milling about, pressing up, and these new structures have been built.
Okay, so but has the client gone over and addressed these issues?
We've spoken to Mr. Mastrangelo about this.
I mean, I can't speak to that since I've only
Well,
been
she can,
involved.
obviously.
I think there were some discussions early on to try and resolve it different ways, but nothing
Ms. Smith,
seemed to
have you
work.
gone over to him and mentioned to him the problems, the impact?
I discussed with him when he put a roof over 3 of the picnic tables that I did not like it and that it was not legal. And he said, I know, but the previous one wasn't either.
Mr. Sullivan, to your point, Attorney Anderson informs me that he's had a series of conversations over the years with Ms. Smith around mutual issues, including parking, potential easements, and I don't know if he wanted to add any perspective.
Well, I guess where I'm going with this is, if we were to take a draconian view of this, and an establishment was coming down before us, a new establishment at this locus, and we were to say it's in a C1 zone, and we are being asked to grant a variance. The question is, what is the impact of this new establishment at this locus outside of the ordinance? And we look at that and so on and so forth. This is an establishment that has been here for many, many, many years.
20 years.
And has coexisted, and it seems to not have a problem, or possibly has expanded. This is what I'm trying to get my hands around, as to what the tipping point was a year ago, 5 years ago, 10 years ago, or whenever. Never been to the establishment, drove by it a million times, and has seen it somewhat creep a little bit, but I never really paid too much attention to it. So we look at the impact of what it is, and yet, and again, Council, unless you want to refute some of the reviews, and that sort of resonated with me, some of the reviews of the B&B. Now, you may come back with 10 reviews saying just the opposite. I don't know that, but I'm just trying to figure out if it really has seriously impacted the neighborhood to the point where we should not allow it to continue. And that's the question that I have.
Well, I can briefly respond. I think some of the reviews that Attorney Rafferty was discussing were from 2 or 3 years ago. And that's when the ramp up started of the increase in business. And it does impact the bank. She has to keep her windows closed. Some of the guests are complaining. It does impact it.
I'd only make the observation too, that it's just not Ms. Smith who's opposed to it. There are a lot of other neighbors who are opposed to it too, so.
Yeah.
Ready for discussion? I'd be happy to go first, but if anyone else wants to go first, go ahead. Feel free.
No, go ahead, Gus.
Thanks a lot, Jim. Frankly, a case like this is a case where I wonder why I sit on the zoning board. If I ran the zoo like Jerome McGrew from Dr. Seuss, I'd allow this business to go ahead. It's a business that's been here for 20 years. It's a business that's somewhat iconic. It does have an identity. There's obviously a lot of people inside the city and outside the city who want the business to continue. But I also have to deal with the fact that I'm a member of the Zoning Board of Appeals, and I'm charged with enforcing the zoning laws of the city of Cambridge. And I am afraid to say I don't think from a zoning point of view I can vote in favor of relief. The fact of the matter is that you have to meet two things. You have to meet the standard for a variance. You need to have a substantial hardship. The hardship has been identified by Mr. Rafferty as you being forced to close down a thriving business. But the fact of the matter is, rightfully or wrongly, and I accept your testimony as to you're innocent about it. This business was not supposed to be here when you started under our zoning laws. And you did it, and yes, the neighbors didn't complain, but you did it. And so I have a lot of problems with saying it's a substantial hardship that you have to close down a business you should have never started in the first place. The second standard is the hardship is owing to circumstances relating to the soil condition, shape, or topography of such land or structures, and especially affecting such land or structure, but not affecting generally the zoning district in which it is located. You don't meet that standard. There's nothing. This is a standard property. It's got a two-family house. It's got some commercial activities which exist as illegal. I take it as a legal non-conforming use, but you don't meet the standard for the rest of what you want to do, namely the seafood restaurant and the retail operation. So I look at all this, and with a great deal of regret, but I have to say, as a matter of just integrity, I have to vote against this. I do believe that you should seek to go to the city council. They're the ones who said this area is to be zoned residential, this to be used for residential purposes. And if they want to change it, that's their prerogative, and that's where the bug lies. And to your point, Mr. Rafferty, you cite the case correctly, but I think you mischaracterize it to some extent. the court said is that the court, in making a decision on a use variance, the zoning board can look into basically the general area, the other non-conforming uses. But it doesn't say you have to grant relief because of those. And I'm very much worried about what I'm going to call zoning creep. If we allow this non-conforming business, what about some of the business in a residential district near another business area, or have a number of non-conforming uses? We're going to undermine the zoning classification that the city of Cambridge wants. They want certain areas to be used for certain purposes. And we're supposed to vary that only if we meet the very rigid standard that I identified earlier. And as I said earlier, we have given that relief, but it's only because there is no alternative. The fact of the matter is, someone who's got a garage that's been used for years as in a residential area, and it's been used for business purposes, and it can't be converted to residential except by tearing it down. And we've allowed a new business to come in and use that. We haven't granted relief beyond that, in my memory and my judgment. So I come down with, regretfully and probably in the minority, but I come down on the basis that I could not support a grant of a variance as requested, even with the conditions that have been suggested by the petition.
I understand. I would only offer
debate my comment.
note that the notion of precedent I'm very respectful of, and I understand the board, but it cuts both ways. The notion that we don't do that, so we can't do that here, and other variances don't apply. I would only say that the authority rests within the ordinance for the board to grant use variances. There have been use variances granted. They are not on their face something that is in contravention of the integrity of the ordinance. And I would say that every case, and I know the board believes that every case is judged on its merits, and the uniqueness is a very relevant criteria in zoning. I don't disagree that the court doesn't say that that's a dispositive finding. I'm just saying that's a factor in assessing this. And this case would be a very different case if this was on a different street in a different location. I think the board would have a much easier time in being able to conclude that the incompatibility of a use like this in a purely residential setting would be so detrimental that it would contravene the ordinance.
I thought you had. I've been very patient, but don't debate my conclusion.
I agree.
You had your time to make your presentation. You made it. I'm giving you my reaction to that.
Understood.
Anyone else want to speak, or we can go to a vote?
No, I want to speak. I think it's a little unfair to characterize this situation as Mr. Mastrangelo as doing an illegal business. I think when he first started as a wholesaler and he converted his garage as a wholesaler, that was legal in the district at the time. I think that the business has grown into the retail and restaurant business, and I think he has been given tacit understanding that he was allowed to do that all through the process by licensing boards all along the way for the last 20 years. There may be at some point where he realized that this was a problem, and he didn't do anything about it. But he's been getting the stamp from the city to continue his process. To continue his.
Tim, I don't want to argue with you, but I think that...
But you're gonna.
You're right. But the stamp is, he gets inspected. The people don't inspect for health.
I know it's not an ordinance. He's not been
It's not
stamping.
And the only stamp of approval he's got.
I said all that just to make sure that he's not characterized as being 20-some years of wrongdoing, because I don't think that's the case here. I think the case here is some confusion over zoning issues on his part, some confusion on the city's part over zoning issues until just recently, about, if I look at this map and the way it was rezoned, I'd say there was confusion over the zoning issues at that point in time too. I mean, he's butted up against by a BA and a B3 and open space and all around him. I mean, this C1 that extends down into that block between Putnam and Blackstone is mostly not residential. There's a tiny little tip of residential in which his house happens to stand. And if you look at Western Avenue all the way up, with the exception of one block on either side of the street, he would need the same kind of relief a use relief that he's asking for in the spot where he is now. There's only one spot where you have a BA along Western Avenue, BA3 along business along Western Avenue. I think that Heather Hoffman raised the issue of a benefit to the public, and I think that overwhelmingly the testimony here is that this is a benefit to the public. And because of that, because of where it's situated, because he seems to have been given the go-ahead, and because we are empowered to make those variance decisions in spite of an ordinance which is foreboding and confusing. Look at this map. You wouldn't even be able to read this, most of these people in here. That we're well within our power to grant a variance in this situation, and I'd be in favor of it.
Anyone else wish to speak, or go to roll?
I mean, I think, he's been coexisting for 20 years. I think what I heard tonight is that the resistance came about as his business started to expand. And I think we can control that with the conditions that that are being imposed, self-imposed, but we can add conditions to that as well. So if the PA system is a problem to the neighbor, let's say there's no PA system allowed. If the structures that are built within the setbacks to complain to the inspectional services, and those structures will be taken down. So there are things in place that I think can control what he's doing. I think what he's been doing for 20 years has been a great service to the community, and I'd hate to see that disappear.
Before we done, you made a suggestion, Tom, about maybe we need more conditions in here to make it work. Are we ready to do that tonight, or do we do everybody, having the basis of all the testimony we've heard, we want to think about it and come back? Just in your view. I mean, otherwise, we've got to sit there and puzzle through before I make my motion to grant the variance.
Well, I mean, the only other two things that I heard was the PA and the structures that are built within the setback. And of course, the smell. But the smell, again, we can put a restriction in there that it be evaluated. There are charcoal filter systems that can be installed on his exhaust system that can control the smell. There are things that, we can do to, I think, control the expansion of this business and keep it so that it is a small business within a residential district. Those businesses occur throughout the city.
George, I'm sorry.
The thing that I'm looking at also is the integrity of the individual that comes to us. And I can believe from things that have gone on in the city of Cambridge that he has heard that he has been grandfathered in. I can believe that. So therefore, from where I sit, if you feel that you're grandfathered in, why would you go any further? So I mean, that's just my common sense or my logic about that. Somebody says, an official says to me that you'll be grandfathered in, don't worry about it, they're changing everything around you, then I'll trust that public servant. So that's where I sit.
Well, I could almost answer your question to Tom. I would be leaning towards granting this. Now, getting far as conditions, because I've heard some adverse impact that this has had, but I don't know the extent of that. And again, we're sort of pushing and pulling and so on and so forth. Not to delay the agony, but what I would like is almost a laundry list, if you will, of what the actual violations are and how we could possibly, not maybe all of them, possibly clean up some of those. Maybe the tables, so on and so forth. Obviously, the exhaust, the noise, and the fumes are the big items. And how those can be ameliorated would go a long way to getting my absolute yes vote, and to find out what are these other things that have impacted the abutters. And until you get sort of a definitive, this is a violation, does it make sense to keep it or to eliminate it or whatever it may be? Obviously, the exhaust, the noise, the fan are big items. And what steps would the petitioner, if we were to grant them, and if we were to make a positive motion to insert that as a condition?
That also goes for us, my question for Tom.
That's right.
Continue the case for a further, a more detailed presentation on the...
Correct. That's, in order to do it intelligently, I think.
Well, I think that's right. We can't do this condition if we're going to pass this on...
I don't know, and I would not be comfortable pulling and grasping, because I don't know the extent of it. I would want to know the extent, and some of the things possibly could stay there, so that if we were to make a motion in the affirmative, that it would be with these conditions, but also then leave the rest of the package intact.
What do you mean by the rest of the package? I'm sorry.
Building, activities, whatever it may be, something like that, and then maybe not require enforcement, so that when the petitioner did leave here, it was not just then to set off a whole other chain of events and reactions. I think I would like to, if we're going to vote in the affirmative, that once he leaves here and it goes through, that's another whole issue, that then he's able to operate in the clear and not have some of these other issues hanging over it.
Okay, then I'm going to...
Chair, could I submit, I apologize, but there's a model that has proven successful. These issues often arise at license commission meetings. And abutters have concerns, and the applicants are then told the matter is continued. Meet with the abutters, identify the impact issues. In particular, I had a case recently about acoustical issues, ventilation issues. Have someone get out there, bring in an engineer. We had a recent restaurant, very popular restaurant, the Dumpling Room House, right
On
at
50 Mass Ave?
Yeah. In a condo building in the condo waters, and we met, and with good engineering, some money spent by the applicant, there are systems, as described by Mr. Scott, that can be employed that mitigate this. And not to say that we reach complete agreement on every issue, but a list of impacts is compiled, a proposed mitigation is addressed, and then the board can be the ultimate decider as to whether the proposed mitigation...
No, we would be the final arbiter of that.
Well, that again argues for, not argues, demands we adjourn this case, continue this case, I'm sorry. Continue the case. The burden will be on you to come back to us with proposed additional restrictions beyond this based upon what you described as to do with the licensing board. I would urge other board members to think long and hard about what they've heard tonight and see if in their own minds what restrictions they might want so they can better evaluate what you're going to propose. So, on this basis, all on this...
Does that make sense, Tom?
Yes,
Tim?
I agree. Yeah, I wouldn't argue with that. I would advise you to err on the side of over-licensing or over-inspection, over-thinking.
I think that's good advice.
Where we cover every possible.
I think we've got a great incentive at the moment to try to be as thorough as possible in addressing these issues.
Okay, the chair moves that, what's the, first of all, what's the next available case?
December 10th.
December 10th. That could be, let me ask you first, will that be enough time for you?
Oh, sure.
Okay. Can all the members of the board be here on December 10th?
Yes.
Okay. The chair moves that this case be continued as a case heard until 7 p.m. on December 10th on the following conditions. That the petitioner sign a waiver of time for decision, Mr. Rafferty is very familiar with. That the posting sign that you have up there now, modify it, a magic marker, change the date to December 10th, the time to 7 p.m. And that these restrictions that you're going to make propose to us in addition to this, maybe make a comprehensive list, be in our files no later than 5 p.m. on the Monday before December 10th. And I will tell those in the audience, anytime after 5 p.m. on December 10th, you can go down to Special Services and view what the petitioner is proposing. And we'll give you the opportunity at our hearing on December 10th to comment on them. You want more or less, whatever. That'll be the jumping off point. All those in favor of continuing the case in spaces, please say aye.
Aye.
5 in favor. Case continued to December 10th.
Thank you. Thank you.